Well, welcome everyone. I'm so glad we have a great turnout. And I want to tell you just a little bit about this series. This is the Tom Sager Speaker Series. And I couldn't be more pleased that we have a speaker series named in honor of Tom Sager. Tom Sager is a graduate of this law school. He was litigation counsel at DuPont. Because of his impeccable character and great legal skills, he went up the ladder at DuPont and became general counsel. As the general counsel of a Fortune 100 company, he was under a lot of scrutiny, and what he did was earn a name for DuPont as a corporation committed to diversity. He earned for himself the name of someone who diversity in the legal profession has been a lifelong passion. He's known for that, and he's known as a great innovator, and I know him as one of the graduates I'm proudest of. So this is the anonymous donor, gave the money to fund the speaker series and wanted it named in honor of Tom Sager, and I certainly see why. So with that, I'll turn it over to Omari Simmons, our own Professor Omari Simmons. You all know him. He is the appropriate person to be interviewing Justice Holland because Professor Simmons was himself a law clerk on the Delaware Supreme Court, law clerk for Justice Norm Vesey, Chief Justice Norm Vesey. He was corporate counsel for several multinational corporations. He's an innovator. He started on his own, came to my office and said, we ought to have a business law program and I ought to be the director of it. And I said, yeah, true to both of those things. So I'm proud to turn this over to Professor Omari Simmons.
All right, thank you. Now, can you hear me? That's great. Well, I have to say it's a great pleasure to be here, to be able to introduce today's speaker, Justice Randy Holland of the Delaware Supreme Court. I have to say that I've known Justice Holland for over 30 years, and in my opinion, we really hit the jackpot. We couldn't have gotten a better representative of the highest ideals of the legal profession, the judiciary, as well as public service. I think it's also great with regard to this being the inaugural Sager Series speaker that we have Justice Holland. And in fact, there's a very strong Delaware connection between Tom Sager, who actually is my former boss and colleague at DuPont. But in addition to that, Justice Holland and I are both from Delaware as well. A couple of facts about Justice Holland's background, and then we'll get to the general interview. Justice Holland is the youngest person to ever served on the Delaware Supreme Court, to which he was appointed in 1986. In March of 2011, the governor of Delaware reappointed him to a third term, for which he was unanimously confirmed by the state Senate. Before joining the bench, he was a partner at Morris Nichols Arnston Tunnel in Wilmington, Delaware. He is active in numerous organizations and is the former national president of the American Inns of Courts Foundation. He has received numerous awards, including the 2014 American Inns of Court Powell Award for Professionalism and Ethics, the 2012 First State Distinguished Service Award, and the 2011 Dwight D. Opperman Award. And in 2004, he was elected to be an Honorable Master of the Bench at Lincoln's Inn in London. He's also written and co-authored or edited 9 books. Justice Holland received his bachelor's degree from Swarthmore College, his law degree from the University of Pennsylvania Law School, and a Master of Laws from the University of Virginia. He also holds honorary degrees from the Widener University, but also an honorary doctorate from his alma mater, Swarthmore College, which he was awarded recently. So it's with great pleasure that I present to you Justice Randy Holland. And so format for today, the way we're going to go is probably for about 30 minutes. We'll conduct the interview in a range of questions, and then after that, we really want questions from students as well. I think we have a number of people in here, enough people in here, to generate some really good and interesting questions. Although the general topic today was supposed to be the enduring importance of business courts, and we're going to talk about that, I thought it would be good to get started with some background information. So, Justice Holland, can you tell us a little bit about your background and practice background prior to joining the bench?
Sure, and let me say first, thank you for having me. It's an honor for me to be here, especially at this inaugural lecture. And I think it would be appropriate to start by having Tom Seger stand up so we can give him a round of applause. He really is, as the dean said, one of your most spectacular alums. And I always knew that I wanted to go home to practice in the area where I grew up, which was a rural community, and I joined a firm with 3 lawyers. And within the first year that I was there, 2 of those lawyers became judges. So that left 2 of us, and it was a great opportunity for me because, as you can imagine, they left behind a lot of clients who needed someone to do something, and I had an opportunity to do things that I normally wouldn't do. And over the next 7 years, the 2 of us expanded the firm to 8 lawyers, and we had 30 people on our staff. And then I made a lateral move to become a partner in a major law firm, and I did that for about another 6 years before I joined the court. It was a great opportunity for me because half my practice was litigation and half of it was transactional. And by the time I was appointed to the court, I had appeared before almost every judge in every court in the state. So you immediately know Delaware's smaller than North Carolina.
Okay. Now, in light of that, what cases or clients do you remember most or had the biggest impact on you?
Well, the reason I became a lateral partner is because my practice had grown and become fairly sophisticated. And so you would think that your most memorable cases would be large transactions. But I think that the cases that are most memorable to me are the ones that involve helping individuals. And these I did pro bono, and I encourage all of you to think about doing pro bono work. And the first case I remember is someone who came to the office and was in the reception area crying, and I usually didn't see people who just walked in, and I talked to him, and he said he was going to jail, and he had just been sentenced for his second driving under the influence case, which involved mandatory jail time. But before he pled guilty, no one told him it was mandatory jail time. And this was going to affect his life in a lot of ways for a lot of reasons. And I just thought to myself, well, that's really not fair that they didn't tell him he had to go to jail. So I represented him at the lowest level and eventually took the case to the Delaware Supreme Court because I just thought this wasn't fair. And the result was a Delaware Supreme Court decision that now requires everyone to be told what's going to happen in writing, and it also requires those types of colloquies to be recorded. So and I felt good for him and good that we were able to make this systemic change. And the other case that really comes to mind is someone who, again, came into the reception area, and his story was that he was living in his car. And I listened, and it turned out that he had a really good claim for workers' compensation. So I said, well, we'll see what we can do. And it worked out, and he moved out of his car. So, you know, in both of those situations, you felt like you'd made a difference in an individual's life. And while, you know, many of you will be representing corporations, and we're here talking about corporations, and that's very important, I'm always influenced by Justice O'Connor's thoughts that when you have a law degree, you've got the key to the courthouse, and you really need to use it for rich and poor alike. And so I think, for me, those were the most rewarding cases I had, and I think you'll probably find they are for you too.
Okay. Now on to the Delaware Supreme Court. Oftentimes, a lot of students are hearing about corporate cases. but the Supreme Court is a court of general jurisdiction. So could you talk about the court's docket, and what is it like a typical week on the Delaware Supreme Court?
Well, all state court systems are different. The Delaware judicial system is somewhat unique because we don't have an intermediate court of appeals, and which means if you have a trial in the family court, court of chancery, or superior, you come directly to the Supreme Court. And we also don't have any discretion. We have to take every case. So the result is we have one of the largest caseloads in the country, and the jurisdiction is diverse. The corporate cases that we'll be talking about get all of the national publicity, but they're only about 15% of what we do. 65% of what we do is criminal, and we have the death penalty, and we've had 14 executions actually carried out since I've been on the court. In addition to the criminal jurisdiction, we do contracts, torts, family law, and workers' compensation. So each week, we have all of those variety of cases on the docket. Again, courts do things different ways. We've decided to do oral arguments every week. So we hear oral arguments year-round on Wednesdays. And so for a typical week for us, we're getting ready for oral arguments, we're writing decisions that have been assigned to us in the past, and we're reviewing opinions that are being circulated by the other justices.
Okay.
And for all the professors, we also are reading law review articles.
Thanks for that.
And we even cite them sometimes with approval.
Now, before we launch into talking about Delaware and the business court area, I wanted you just to share what's been the most rewarding part of your job as a judge, or your career, better yet.
Well, I think what's most rewarding is when you can make an institutional change and that has a lasting effect for the greater good. And, you know, I'll just give one example. In the family law area, we hear appeals from termination of parental rights. And that's when someone's parental rights have been terminated and their children are going to be put up for adoption. And as we heard those cases over the years, we realized that the termination was really the function of what happened initially when the children were taken out of the home of the parents. So in a typical case, social services will come in and say the parents are neglecting or not supporting the children, and they literally take the children out of the home and put them in foster care. And then the goal is to see the parent turn their life around and get united with the child if possible, and if not, then you move towards termination. And as a result of those facts, by the time you get to termination, if you haven't succeeded in turning your life around, the end's pretty predictable. So we concluded that the best way to give the parents a full and fair opportunity to turn their life around was to give them an attorney at the neglect and abuse stage. And that was the holding of the Delaware Supreme Court. So now you have a right to counsel not only at the termination stage, but at the dependency and neglect stage. And I think that's been a good institutional change. And I always enjoy talking to family court judges who are telling me stories about parents who successfully turned their life around and were able to get their children back.
Okay. Now moving on to talking about Delaware business courts. We often mention in our corporations classes that 60% of the companies that are publicly traded in the U.S. are incorporated in Delaware. But yet Delaware at the same time is one of the least populous states in the country. And so in light of that, why Delaware? Why are they choosing Delaware, from your opinion?
Well, it's really the result of a series of unconnected historical events, and eventually the stars were aligned for people to come to Delaware. But what I mean by that is in 1792, we decided to keep a separate court of chancery, and that had equitable jurisdiction equivalent to what it had been in England for 1,000 years. And we were doing that because we liked the law of England. You know, if you look at the Declaration of Independence, it wasn't that we didn't like the law of England. We did. We just thought that King George III was denying people the rights of English citizens. So Delaware not only kept the common law of England, but it kept the Court of Chancery. And then if we come forward 100 years, and Delaware didn't have a corporation statute until 1899. And they copied New Jersey's statute because all the corporations were in New Jersey. And Woodrow Wilson was the governor of New Jersey before he was president, and he didn't like corporations. He thought the idea of limited liability was unseemly and encouraged the corporations to leave New Jersey, and they came to Delaware. And when they came to Delaware, the question was, who is going to have jurisdiction over shareholder and directors' disputes? And the Court of Chancery had been deciding cases for trustees and guardians, where people took care of other individuals' money. And the thought was, well, directors of corporations are taking care of the shareholders' money, and they look like fiduciaries. Let's put the jurisdiction in the Court of Chancery. And there were two unintended but salient consequences. First, the Court of Chancery did not have juries, and the corollary to that was every time someone had a case in the Court of Chancery, there was a written opinion by the chancellor. So the more the cases were decided in Chancery, the more the law became established, and the more predictable the law became, and the more inclined people were to come to Delaware. So if it hadn't been for retaining a separate Court of Chancery and New Jersey not liking corporations and Delaware deciding to put the jurisdiction in the Court of Chancery, all of those things, if all of those hadn't combined, we wouldn't be where we are today. And the reason more than half of the publicly traded companies come to Delaware and most of the Fortune 500 companies come to Delaware is because they'd like to know how to stay out of court. So when Chief Justice Rehnquist came to Delaware in 1987 to celebrate the Court of Chancery, he said, what makes Delaware unique is that it has 100 years of established precedents that people can rely on to order their clients' lives so they can avoid litigation.
And speaking of that, we talk about the question sometimes of incorporation, but there's also the issue of just the courts and why people are locating in Delaware or decide to resolve their disputes in Delaware. Could you elaborate a little bit more on the role that Delaware courts play in the development of corporate law in this country?
Well, there are 5 judges on the Court of Chancery. That's the trial court, probably the most well-known commercial trial court in the country. And there are 5 justices on the Delaware Supreme Court. And most of the justices have either been on the Court of Chancery or been corporate practitioners. And that means that 10 individuals are developing the corporate law. So there you get some consistency. And to put that in perspective, there are 1,000 federal judges, and they're all great. I mean, really great. But if 1,000 people were developing the law, it's obviously not going to look the same as if 10 people are developing the law. And then there are a couple of constitutional reasons why the Delaware law is predominant. And one is the internal affairs doctrine, which means that all of the other 49 states have to apply Delaware law to a shareholder-director dispute, which is an internal affair. And as a result, our court develops a lot of expertise through repetition. And one of the reasons corporations like to come to Delaware is because they can get a quick answer. We have a self-imposed rule that we have to decide everything in 90 days of submission. That's our court and the Court of Chancery. And on the average, the Delaware Supreme Court will give you a decision in 40 days. So you can tell your client, if you have a case in the Delaware Supreme Court, we're going to get our decision within 40 days of oral argument. And sometimes even if you lose, it's good to know you lose. Now we decide that, use that timetable for all cases, not just corporate cases. But to just give you one example, 18 months ago, we had a case involving a $9 billion merger. And we knew when we took the case that they needed an answer on a very accelerated timetable. And I was assigned to write the decision for our court, and nothing can be released unless all 5 justices sign off in writing. So we were able to circulate and agree on a 50-page opinion in a $9 billion case in 7 days. And it's only because we're familiar with the jurisprudence. And other courts may have superb judges, but they just don't see the cases as frequently as we do.
Okay. No, in light of that too, another follow-on would be, often sometimes things are not discussed are actual internal rules. So there are any internal rules in how you go about even delivering opinions that might contribute or help the situation?
I think so. Our internal rules are published, so I'm not telling you any secrets. But we initially sit as 3 justices unless it's a death penalty case or a case of first impression, or unless there's a disagreement. If the 3 justices disagree, the 5 of us hear it. And the reason we do that is because it's the only way we can keep up with our caseload. So if 3 agree, it's unanimous. And we have a rule that none of the justices can talk to any other justice before a case is argued. And our law clerks don't talk to each other also between chambers. That means when you go to oral argument, everyone's equally prepared and equally eligible to have the case assigned. And the case is assigned by the senior justice, which is usually either the Chief Justice or me. But and now our oral arguments every Wednesday are live on our website in real time. But if you know that we don't speak to each other, then when you hear the questions from the justices, you know that they're really talking to each other by asking the lawyers questions. After we have oral argument, we speak in reverse order of seniority. Everyone gets to speak once without being interrupted. I was the junior justice for 8 years. I thought it was like eternal hazing that I always spoke first. But then if we can reach a consensus, the senior justice assigns it. And as I said, the assigned justice I would call the primary draftsman. So if you see my name on an opinion, I was the primary architect. But literally nothing can be released unless all justices sign off in writing. So if you see an opinion of the Delaware Supreme Court, it really is an opinion of the court. It was mentioned that Professor Simmons, clerk for Chief Justice Veazey, I always smile when I think about his service on the court. He had his primary concern was that you never started a sentence with the word however. So whenever I circulated an opinion starting with however, he'd circulate it and send it back. And then I recall once he told me that I had 2 split infinitives on one page, and he could have let one go, but he wasn't going to let 2 go on the same page. And the reason I'm telling you that is because it gives you the attention of detail and engagement that all 5 justices have in every opinion, even if they're not the named author.
You talked about sort of the internal affairs of corporations that state law normally governs. But in addition to that, there are federal laws that impact corporations as well. Could you talk a little bit about the interaction between the federal government and state law on the question of corporate law and corporate governance?
Yeah, I think the relationship between state and federal law has been described as a symbiotic relationship. And when the Securities and Exchange Acts in 33 and 34 were adopted, they pretty much focused on disclosure in publicly traded corporations. But the federal statute initially provided that fiduciary duties would be controlled by state law, and that would be the law of the state of incorporation. And that continues to this day. Now, there's certainly overlap. I often say that if you're a director of a publicly traded corporation, you need to look in 2 directions. One is your fiduciary duty under Delaware law, and the other are your obligations as a director of a publicly traded corporation. Over time, there have been a lot of challenges to that division, but just a couple of examples. In 1998, when the new Securities Act was passed by Congress, they put in an exception called the Delaware carve-out, even though they never used the words Delaware. And it basically said that securities cases would be in federal court unless it was the type of case that had been previously decided in state court, which would be individual actions, class actions, and derivative suits. So there was a carve-out in the federal statute to permit Delaware to continue developing these fiduciary rules. Then, with the collapse of WorldCom, Enron, and Sarbanes-Oxley and Dodd-Frank, there was a lot of pressure to have a national corporation law. Why have corporation law dominated by Delaware? And it was interesting that Congress was really lobbied by Wall Street lawyers and lawyers from around the United States saying, you should leave the division alone and continue to allow these fiduciary duty cases to be argued in state court in Delaware. And that's pretty much how it came out. Now, having said that, there have been some limited inroads on what would otherwise be internal affairs by requiring independent directors to be on certain committees or exclusively on certain committees. But the dichotomy I described is pretty much remains through this day.
Well, the next question I had, we've talked about sort of Delaware in terms of its influence domestically. I wanted to see if you could speak to the influence of Delaware precedents and on global disputes, but also in influencing other foreign jurisdictions.
It's interesting to see what's been happening around the world, I would say primarily in the last 10 years. We definitely now have a global economy. So people from around the world are investing in other countries. And if you're an investor, your first question is, well, what's going to happen to my money? What are the rules going to be? What are the fiduciary duties of directors? And what we see today is that many multinational corporations, especially when they're combining to do business in other countries, will create a Delaware entity, a Delaware corporation to do the business, because they know the Delaware courts and they know the Delaware fiduciary duties. Now, in response to that, other countries have said, well, what can we do to keep our citizens in our own country? And other countries are setting up business courts, so they frequently ask Delaware justices or members of the Court of Chancery to come and talk about business courts. And they're also looking at the law within their country. And the Delaware fiduciary duties are created by judges as a matter of common law, but other countries are really statutory or code countries. And what you see in those other code countries are the incorporation of the Delaware common law business judgment rule into a statute. And I've worked with the Chief Justice of Taiwan in setting up business courts. I've spoken in Qatar on a program entitled Doha to Delaware. How can Qatar become the Delaware of the Middle East? And Qatar, Dubai have set up commercial courts, and other countries that are setting up commercial courts look to Delaware as an example. Now, the Delaware law isn't adopted by everybody, and it doesn't work for a lot of reasons in a lot of countries, but it's kind of the default position because Delaware has been doing it for 100 years.
What are some just general events that have happened in the environment of business that you think have shaped some of the court's work over the past decade?
Well, I think shareholders have become more active and sophisticated, especially institutional investors. And there's been a lot of tension between shareholders and directors and their rights and responsibilities. And that certainly played out in the courts. And I think as Delaware has developed the fiduciary duties, there's a real emphasis on the importance of independent directors and decision-making by independent directors, especially on an independent committee. And I think that if you looked at our jurisprudence you tried to identify one theme, the Delaware courts are really looking at process. They really want to know about the process. And so I think those are, the things that are influencing where we're going the most.
One of the things recently announced that actually at this law school we're going to have a North Carolina business court. And I wanted to see if you could speak to that, to some of the benefits that may provide for litigants, students, and other constituencies.
Yeah, I was very happy to hear that. Recently retired Judge Ben Tennille from North Carolina, who was instrumental in starting the business court in the late 1990s. And he's been back and forth to Delaware many times, and I've gotten to know him over the years. And he saw the advantage of having a business court that would develop expertise through repetition. So he encouraged North Carolina to set up a business court. The one at your school will be the fourth one. And he was also instrumental in creating a national group of business courts, and he was one of the initial leaders, and one of the vice chancellors from Delaware was also the head of the national group of business courts. Delaware doesn't take a parochial approach to business courts. I mean, they're happy to just go and talk and tell people what we do and how we do it, and we've had a lot of interactions with North Carolina. And I think that this will be great for the school to be able to see some of these business cases litigated firsthand.
Okay. With the time, I want to ask another question, and since we have you here for the students, what advice would you give to the students, and what advice can you offer to aspiring lawyers in the room regarding building a career?
Well, my advice may seem mundane and somewhat simplistic, but it worked for me in 2020 hindsight. So first I would say, do your best at whatever's in front of you. Just really do your best. As a lawyer, you're going to have a reputation. And, sometimes you're in a big firm and all your hours may not get billed. Sometimes you're in a little firm and you may not get paid for everything. But it's your reputation on the line in every single project you have. And you just need to do the best on the project in front of you. In addition to that, I think, there's no such thing as a bad experience. As you go through life, you're going to be drawing on a lot of experiences. I started out in a small firm. I never aspired to be a judge. I was kind of drafted to be a judge. But along the way, I appeared in the Justice of the Peace Court. I appeared in the Family Court, the Court of Common Pleas, the Superior Court, the Court of Chancery, and the Supreme Court. And now I'm deciding appeals from all of those cases, which I never would have thought of as I was doing them. But along the way, those were opportunities that enriched my career, unbeknownst to me. So I think that you should welcome opportunities, but keep in mind, even if what you're doing may not be your first choice, it may turn out to be valuable in the long run.
Okay. So in the interest of time, what we're going to do, we're going to take some audience questions. And here's a microphone.
Now, I appreciate you all coming, and I have two questions in my own mind. While I would like to think you came to hear me, what was the most determining factor? The pizza or the fact that your professors made you come? And remember, when thinking about your answers, that you always have to be candid to the tribunal.
So our professor required us to come, but
You get high marks for candor.
But I already had it on my Google Calendar to come.
And I believe you.
Before it was required. My name is Lance Henry, and I'm a 2L here. And I'm in business organizations, which is the class that's requiring me to come. And you mentioned in the interview portion that one of the motivations for corporations is avoiding litigation. And so, and we've seen, in biz org's class, sometimes corporations as a whole will even rely on a Chancery Court decision that isn't yet, at the Supreme Court just because they want to do that. And so reading the tea leaves of the, the opinions in the state is a phrase our professor uses. And so, I have a general question, and I'll give a specific example, and if you have a better example, you can use that. But the general question is, do you have guidance for corporate attorneys trying to read the tea leaves, balancing between sort of giving flexibility for their corporate clients, at the same time, helping them try and avoid that litigation that they don't want to get into? A case we talked about today for my specific example was Dodge v. Ford Motor Company, which is a Michigan case. And so I don't think there's no statute in Delaware on this issue of whether corporations can, for example, prioritize employees in addition to shareholders. There are some Delaware opinions, I think, that mention it and maybe cite it favorably. And so, if I'm an attorney advising a Delaware corporate client, reading the tea leaves, do you have suggestions on that?
Sure, and that's a good question. I didn't mention, but this is a fact, that 80% of the Court of Chancery decisions are never appealed. So in reading the tea leaves, you should know that the Court of Chancery decision is the law until the Delaware Supreme Court says otherwise. Now, the 5 people on the Court of Chancery don't have to agree. They're not bound by each other. And frequently we get cases that come to us when there's a disagreement. Conn v. Lynch, which you may read, is one example of a disagreement. But a better example of reading the tea leaves is in director oversight. Directors have to make sure that they're monitoring what the corporation does. And the Court of Chancery decided a case called Caremark 10 years before the decision I wrote for the Delaware Supreme Court in Stone versus Ritter. And in Stone versus Ritter, we said Caremark was a correct statement of the law. And for 10 years, everyone assumed that, even though it was a Court of Chancery decision. So in Delaware, you're very safe in relying on a chancery decision where there's no internal disagreement, even though there hasn't been a Delaware Supreme Court case.
Okay. Any other questions? Oh, there's a question in the back. Okay.
My name is Dan Mick, and I'll be practicing Delaware in the future. I was just wondering, with the passing of the Delaware Benefit Corporation statutes, where you see the court going and analyzing transactions between corporations that have taken the public benefit corporation fund.
Yeah, we haven't had any cases, and by way of background, Delaware's, by statute, created the possibility of creating an entity that really is for the public benefit, to be distinguished from what I'll call a plain vanilla corporation that's interested in doing what's best for the shareholders. Now, the traditional corporation has always been involved in philanthropy, but you normally have to show the philanthropies tied to the good of the shareholders by creating goodwill or doing other things. But and this is something that's interesting and evolving, but we haven't had any cases yet.
Any other questions?
Hi there. My name is Ethan White. I'm a current 2L here. I'm also in the business organizations class that forced me to come, as well as the free pizza.
But you're happy you came, right?
I am happy I came. My question is, what do you see the role of a corporate attorney being in regards to ethically steering a business? We've talked a little bit in our class about how much involvement attorneys should have when they're corporate attorneys in ensuring that businesses are making ethical decisions. When should you really be pushing for one decision versus when should you just be counseling the board of directors and your client on what the law is and what the appropriate decision would be, and then stepping away or standing down if you believe that they're not making an ethical decision?
Yeah, well, I think the best example of a person who lived their life that way is Tom Seger, who's here today. And I think that my advice would be, when you're involved with a client who doesn't want to do what you think is ethical, that's the time to suggest that they get another attorney.
Thank you.
I mean, I'll tell you a funny story along those lines. When I first started out as a country lawyer, I didn't think anybody'd ever come to me. So one day, someone I went to high school came in and said, "Would you represent me in a real estate settlement?" And I said, "Wow, this is great, my client." And the next thing I knew, this well-known realtor came in and said, "Here's the deed that we're going to use for this settlement." And I looked at it, and it was, the name of the buyer was blank. The seller had signed it. It was already notarized. And it said the consideration was $10,000. Now, my client was going to be paying $15,000. And the realtor said to me, "Well, just fill in your client's name." I said, "Well, we can't do that. We've got to put in the name of the original buyer and pay the the transfer tax on $10,000, and then pay the transfer tax on the $15,000. He said, "No, well, that's the whole point of having this blank deed. We're going to skip all those taxes." And I said, "Well, I'm not doing that." And he said, "Well, you need to talk to this." He said, "I want to talk to the senior partner." And we went in, and the senior partner backed me up and said, "We're not doing that." And as the realtor went out the door, he looked at me and looked at the partner, said, "Well, I can tell you one thing, that young man is not going very far."